everyone. Happy spring. Happy, what are we, May now? This is May 5th. I hope, hey, Mike Polito, haven't seen you in a while either. May 5th, and hopefully we'll actually see the sun this month. We've been getting our share of rain for sure, right? We got a little sun breaking through the clouds, but Paul, I owe you a call too. Paul DeBio, I see you out there. I know I owe you a call. Just wanted to say my usual disclaimers, right? That these are informational purposes only. This is not legal advice. We don't represent people by giving these seminars. If you do need an attorney or actual legal advice, you have to present your actual case and your facts to either us or another law firm or attorney, and generally enter into a retainer agreement. None of the information that we talk about today will be kept confidential. So if you do go down the page and go into the chat room and ask us questions, make sure it's not a question about something you want to be kept confidential. So that's that, and hope everyone is doing well. Let's see, we do have a dog of the day today. We do have a cat of the day pending. We'll get that cat up there one of these days. We do discriminate, I have to say, sadly, a little bit against cats. It's not that we don't love cats, but it was dog of the day, kind of just has the D and the D thing. So this is Lola, and Lola belongs to Christina Munson, who is the president and CEO of RCP Management over in Central Jersey, Cranberry area. And thanks so much, Christina, for sending Lola in. That's dog of the day. And today we're going to talk about who signs what. And this is kind of a weird topic. The reason it came up and the reason I put it out there is we've been getting lots and lots of requests to sign things as lawyers, which is really strange because lawyers generally don't sign things. And as we get into the detail, I'll tell you why. The first thing is pretty obvious, right? Contracts. So the contracts have to be signed. Most boards, and I think in community association world, the best practice, especially with respect to significant contracts, is that the board president signs the contract, right? The board president signs the contract. I think that protects management and the board in terms of being engaged and having a record of the contract. And I'll do a separate presentation on this. You've heard me say this over the years. Do not sign the contractors, the vendors' specifications or their bid. Do not do that. Send the specifications and the bid materials over to your law firm and have the law firm prepare the contract. Do not just sign contracts. Generally speaking, vendor contracts are very, very, very much slanted in favor of the vendor and very, very, very much against the association. So keep that in mind. If you're looking at a proposal from a vendor, or if you're somehow tempted to sign a vendor's proposal or their version of a contract, make sure you're looking at what are the price and payment terms, but even more importantly, how do I get out of this agreement if I get into it, right? How do I get out? Is it termination with or without cause? That's what you want. You do not want with cause termination, even though it sounds good from a vendor perspective. The vendor goes, hey, so if there's a problem, you get out. No, with cause termination means you will be paying attorney fees for months and months, if not years, arguing over how we get out of the contract and how we can prove cause for termination. So please, if you take anything away from that, the board president would generally be the signer of the contract, and don't sign the proposals. Have your lawyers prepare the contract. That being said, now the caveat to that is the board can authorize their management representative to sign contracts as the agent. So some associations do allow their management, do empower their managers as agents to sign certain contracts. Generally, it's smaller contracts, and generally it's routine contracts for recurring items. So recurring items, not your larger ticket items or your unusual items. So the next topic is certifications in lawsuits generally. So generally speaking, if this involved a real factual situation, the certifications that are talked about in lawsuits are as if testimony is being given in court, right? So you have to imagine if testimony is being given in court when someone asks you to sign a certification. Because what a lawyer is asking for when a certification is being signed is, I need a statement from somebody with firsthand knowledge of the facts so that I can submit it to the court, and it's usually for what's called a motion for summary judgment, to try and get the case kicked out based on an uncontroverted statement of facts. So for example, if there's a trip and fall case, if the manager is knowledgeable of the facts, if the pavement was not vertically displaced, there was no crack in the pavement, there was no ice there, et cetera, the person with firsthand knowledge would sign that certification. So whether it was the manager or the board president or the association's snow removal vendor, et cetera. So those, when you hear about certifications in lawsuits, generally, it would be the people who have actual knowledge of the facts. So for example, again, if the snow removal person, when was the snow removed? When did the person go out and do the snow plowing? That would be the actual snow removal person. I went out in the truck at 6 a.m. and I plowed the front of the clubhouse 3 times before 9 a.m. and it was clear and dry by the time this person alleges that he or she fell. So that's certifications in lawsuits generally. Certifications in collection cases are a little bit different because of the admissibility of evidence based on regular business records, right? So regular business records are generally certified to by the association's management company, whether it's the property manager, the back office staff in your management company, the bookkeeper, et cetera. But so a certification in a collection case in our world they're typically signed by the association's manager because they're representing the agent of the association that keeps the books and records. Does that make sense to everybody? Generally, they're not signed by the board president. Why lawyers generally don't sign things? Generally, lawyers don't sign things in this context for several reasons. You don't want your lawyer to become a witness in a lawsuit. You don't want your lawyer to be a witness in a lawsuit because often that means your lawyer may be kicked out of representing you in the lawsuit because they'll say he or she is now a necessary witness. And I have to put him or her on the stand and cross-examine her and depose her and do all kinds of fun litigation stuff. So you generally don't want your lawyer in a position of being a witness. So that's why lawyers generally don't sign certifications in that context. The second reason, and actually really is the primary reason, is generally the lawyer's just been in their office, wherever that office has been, and they have no firsthand knowledge of the facts. They have no firsthand knowledge of the facts. So a judge, if you were thinking about going to court, would say, okay, if I put your lawyer on the stand, what is he or she going to tell me? And the lawyer generally doesn't have much to say except for Jeff told me X or Beth told me Y, right? Or Madeline told me Z. That's not helpful to a judge, right? And generally speaking, that's hearsay, which is excluded from evidence, barred from evidence. So what a court would say, and you see these on the Perry Mason TV shows, objection, Your Honor, that's all hearsay. And what happens is Beth or Jeff or Carl or Madeline or whoever, they'd say, bring that person in with the firsthand knowledge, bring that person and put them on the stand, and then I'll cross-examine them because they're the ones who have the real firsthand knowledge and they're the ones who I want to cross-examine. So that's why lawyers generally don't sign things and why it's generally not helpful for lawyers to sign things. What is a notary? So a notary is a person that verifies execution of things, right? Or affidavits of things. Now, the notary is not certifying to the actual content of the information, right? Or the document. The notary is certifying that the person who signed the document, and this is a summary, it's all in the statute, but that the notary certifies that the person who signed it appeared before them, either in person or electronically now as of 2021, and certified that not only are they the person and they have identified themselves with ID or the notary knows them personally, and has indicated to the notary that they have the authority for executing the document that is being executed, whether it's a deed or a contract or a lien or what have you. So it's really two things. The real person is signing it and they have the authority to sign it, right? So if you don't have authority to sign a contract, don't sign it. If you don't have authority to sign a certification or what have you on behalf of the association, don't sign it until you get that authority. And that gets jammed up sometimes when the association's board has not voted in an open public meeting, for example, to sign a contract, right? You know this already, I am not a proponent of, hey, we signed this contract for $100,000 to maintain the decks or to upgrade the decks, and we're going to ratify it at next quarter's open monthly meeting. That is, number one, it's contrary to the statute. Number two, it's very dangerous in terms of wind up triggering a lawsuit with your members for having a problem with your vendor. Becoming a notary. So you can become a notary pretty easily, as the application is online, and we can send you the information for that. It is helpful to have a notary in the association if you have a large enough association, whether it's a board member or a committee member or a management staff member. It helps to have a notary around. Otherwise, you wind up running around to banks. And as you probably all know, bank branches are closing daily, right? Because everyone's shifting the business model to online banking. So notaries can be hard to find, especially if you need to do it on short notice. So electronic notaries, though, as I said, in 2021, well, through the period of COVID, there were provisions under executive orders for allowing electronic notary because of the COVID lockdown. That was placed into the amendments in the statute in 2021, which was very helpful to all of us. So we can do electronic notary now. And this doesn't apply to us, but just for all of you in your personal lives, there's a very, very big caveat to that, which is, generally speaking, speak to your attorney to make sure it's clear, because there's a carve out for many things involving estate planning, wills, competence, etc. All right. So if there are certain, I believe, allowances for notarizing things remotely, even in the estate planning context, but there are carve outs for that. So be careful before you do estate planning work and have things notarized remotely, and then you don't want your heirs or children or family members to have that challenged after the fact because it was remote notary. So speak to your estate planning attorney on that. So like I said, becoming a notary is easy. Can a New Jersey attorney serve in place of a notary? So yes, we often serve as notaries when we go to board meetings. So for example, we'll go to a board meeting, the board will say, hey, everybody, I have 6 liens here. Can the board president just sign it? We don't have a notary here. And whether it's Mike or me or Heather or Weston, who's also on the call with us today, we'll just notarize it just after the meeting, right? So the board president will sign it in our presence, and we will notarize it there. However, right, again, back to the caveat that lawyers generally don't have firsthand knowledge of anything. I have recently gotten lots of calls from different management companies about signing liens, not just notarizing liens, but signing liens. We do not sign liens. We don't sign liens because we are not the keeper of the business records, right? And we have heard recently from at least one management company saying, well, you know, XYZ attorney always signs our liens. That makes no sense. No attorney in the industry, at least in my opinion, should be signing liens. Now, attorneys obviously can, like I said, notarize liens, which is fine, but the attorney should not be signing your liens as if they were the principal. Because again, if there's an issue with the lien, the attorney's going to wind up probably being sued. The management company is going to probably be getting sued, and they may be able to avoid your lien in its entirety, which you don't want to have happen. Be cool and say you saw my wife sign it. Be cool and say you saw my husband sign it. Big issues in fraud, right? Big issues in fraud and notaries. Where was that big in 2008? For those of you who were around for 1987, you know, when the market tanks and mortgages go sideways, everyone's in trouble. And what happens invariably is you find that people have refinanced their homes without telling their spouses. And somebody has notarized documents to suck the equity out of the home, and they have had either someone else, God forbid, show up and sign on behalf of the wife. It's usually the wife, ladies. I'm sorry to say this. Usually nasty, evil men take advantage of the women this way. So they refinance the home, they suck all the equity out, and they spend it on their new friend. So we don't want that kind of fraud going on. And a notary or a lawyer who does notarize something, and I have a friend who got in trouble for this and had an ethics complaint and had ethics sanctions imposed against him for notarizing documents when the person was not in front of him. There was no problem with the documents that he was signing, but somehow he got into a little rub with the client, and they wound up filing an ethics complaint against him just based on that, even though there was no damage. And he wound up with ethics sanctions against him. In the notary world, they will suspend and remove your notary license, right? So in the lawyer end of things, you generally, I don't think, would get disbarred because of that, depending on the circumstances, but you will get severe ethics sanctions because you're actually certifying that the person appeared before you and signed the document with authority for doing so. So you will. So go ahead, Mike.
Just along the same line. So in Ocean County, about 4 years ago, there was an attorney who was not present, notarized something. It was an estate case, and it went sideways, and he got suspended for, I think it was 2 years, because he wasn't actually there and he notarized it. So
yeah, that's a great point, Mike. And think about that, everyone. You're a lawyer. You don't get disbarred, thank God. And as Mike said, I think in certain circumstances you would get disbarred. But even if you don't get disbarred, imagine not being able to practice your profession for 2 years. You know, you're going to be eating a lot of ramen noodles, put it that way, right? You're basically out of business for 2 years because you're not going to be allowed to practice. And very few, if any, law firms are going to hire you after the fact. So people don't want to hear that stuff. So from the notary perspective, from the attorney perspective, it's never be cool. And I've heard that when I was at my prior firm, there were people there who regularly asked for that kind of stuff. And you don't want to deny it, right? Because you want to make the client happy, but you have to say no. If you're a notary, you have to say no. If you're a lawyer, you have to say no. Oh, it's just an accommodation. My wife doesn't feel good today. I'm sorry, I can't help you. Well, it's impossible for her to get here. Her legs are a problem and she can't walk. I'll go to your house, right? It cannot be. There is no exception in my opinion, especially given the fact that in today's world, you can do remote notarization via Zoom or one of the other platforms that allow for remote. For a remote notarization, I skipped a little bit. For remote notarization, you need contemporaneous video and audio, just like we are now, right? So contemporaneous video and audio. You also need documentation, right, of identification. Generally speaking, it's 2 forms of identification. It has to have a picture and or a signature. And the notary act, right? So going through the process of signing the actual document must be recorded and saved for 10 years. 10 years. So the recording has to be saved and archived for 10 years. So people have to keep that in mind because there are even provisions in the act where if the notary dies, they have to, even the estate has to arrange for filing certain things with the Secretary of State. And a lot of this stuff, just so you know, a lot of this stuff is, as Mike mentioned, directed at estate planning issues, because that's where a lot of the fraud and problems happen. And more recently, and this was in the amendment to the Act too, is people presenting, especially to new immigrants, as attorneys, even though they're notaries, right? So you'll have people, and you don't see them anymore, but you used to see them years ago. Immigration Services and Counseling, John E. Smith, notary. You can't do that anymore under Notary Act because it is basically an unauthorized practice of law. A notary can't do that. And there are provisions in here also that if you are a notary and you're assisting somebody with notarizing documents with respect to immigration, you must give them the notice that you are not a lawyer, you are not practicing law, and you can't give them legal advice in their native language, right? So if somebody who's Latino comes in, you got to explain to them in Spanish, and they're Spanish speakers, that they are not lawyers and can't provide legal services. Same thing with Polish, Russian, etc. That message needs to get through, because obviously there are people in the immigration world who were taking advantage of new immigrants, which is not a cool thing. Association liens, like I said, you want to make sure your association liens are 100% kosher. In our firm, we are more than happy to notarize your liens remotely if that's more convenient for your property managers. It's very much a hassle for the property managers to be chasing people all around to get things notarized, and we're happy to speed the process and help management take the load off by doing remote notarization. Many management companies now are having the managing agent sign the liens rather than chasing around board members for liens, which also helps us help you expedite the collection process. So that's a beautiful thing too, because the managing agent can sign it while we can notarize it via Zoom. So it's a beautiful thing. Our paralegals do that all the time. We do have some questions. I'm going to jump right into them. I know we're moving right along. It's 4:30. I will jump into the chat. I know this isn't a crazy big topic, but I do think it needs to be out there because there is some confusion. Anna says, beautiful dog. It was a beautiful dog, right? It looked like kind of a mix of a kind of a husky and maybe an Australian sheepdog or something, but beautiful dog. Please send the info on becoming notary. All right, Carl. Eileen, if you don't mind, we'll shoot that over to Carl. Last week, I saw a car drive through my community that said mobile notary, guests, they come to you. So Chip Hoover, that's a great observation. This is so crazy, Chip, that you mentioned that. So yes, mobile notaries, and there are mobile notaries. In the COVID world, there has been a growth in notary services, right? Because people were compelled to do deals even though you couldn't see each other. So there were people doing notarization on the backs of cars, in parking lots of fast food restaurants, et cetera. We remember the COVID days. But even as of probably 6 months ago, right? Because we're all doing business online now. So I bought a car from my wife and they said, Fran, we don't want to, and the car I bought was being shipped from, it was a used car. It was being shipped from a different state. And they said, we don't want to do remote notary on the car documentation. We, just like Chip said, we will send a remote notary to you because we don't believe you enough. You know, there's too much fraud out there. So a woman came to my home and she refused to come to my place of business. They required her to come to my home. And this is all fraud prevention stuff. So she came to my home. We sat at my kitchen table. We went through the car, whatever dealer's documents, signed everything, and then they shipped the car to me. The real bad part about that, Chip, was I think they charged me like $250 for that notary service, which was insane, right? Because I mean, the lady was wonderful. She was very nice. But I said, wow, you have a great gig here. And as you can imagine, Chip, her response was, I don't get all the money. The car dealership gets most of the money, right? So they're probably charging $250 and she was probably getting $50. But yeah, so they do have mobile notary services. Paul, if an HOA board member is a notary, aren't they barred from notarizing HOA documents? So the answer is, and I have that answer, Paul. It's if you have, it's a spouse or family member, or if you have an interest in the subject matter that is being executed. I'd have to see, Paul, I'd have to check that if another board member could notarize a board president's signature. That's a really good question, Paul. I do have the conflict language here. Most of it applies to family members and those with an interest in the subject matter. Yes, there would be an interest in the subject matter, but I don't know if that would be enough to conflict you out, Paul. I'll check on that and I'll get back to you. Who is responsible for recording the remote notarization, the notary or the person being notarized? So it would be the notary. So the notary is responsible, for those of you online who are notaries, you're responsible for keeping a journal. And in the remote notarization world, you're responsible for keeping the video, which is probably a cost, right? So there's a cost associated with it. So in our firm, we're cloud backed up and all that other good stuff, and we pay for the expensive, fancy Zoom service, et cetera. But that's tough if you're just doing one-off notarizations, right, remotely. Why would you want to do that? So, and again, maybe this car dealer woman who came to my house, maybe she's made a little cottage industry out of it, perhaps, by doing that, and she notarizes enough stuff to make it worthwhile. Like I said, in my case, it was in person, but to the extent she does remote ones, it may be worthwhile for her to have the cloud set up and all. Yeah, so Chip says he's in the wrong biz. He's going to get a van and he's going to start notarizing things. You go, Chip. It's probably a lot less stressful than managing associations or being on the board of association. But yeah, go for it. Madeline says sometimes both the president and the secretary of the board have to sign the document. That is true, Madeline. So usually the secretary signs as a witness, and the notary notarizes the president's signature, right? So usually you don't wind up notarizing both. Do you have to charge to notarize a document in New Jersey? Chris, I don't think you have to charge to notarize a document in New Jersey, but there are regs applying to if you charge and how much you can charge. I don't think you're compelled to charge. I haven't looked at the regs on the fee schedule that notaries can charge, but I do believe that, I just have the act in front of me, but I do believe that there are regulations under the Administrative Procedures Act that limit how much a notary can charge. So I'll have to check on that. Let's see. Bill says other issues can the board deny members petition to amend bylaws with 200 units? How many names required on a petition? Okay, so that's a side issue. That's fine, Bill. Thanks. Can a board deny a petition to amend the bylaws? So generally speaking, a board can deny any petition. Where things get funky is, and this is off the top of my head, you'll have to look at your documents and I'd have to pull out Radburn again. Generally speaking, the memberships can compel the board to meet and have the membership consider a petition if it's signed by, I believe, 20% of the membership. It compels the board to put an issue in front of the membership. So that's where things get funky. Hey, Ray put up the whole statute there. Oh, the fee schedule. Thanks, Ray.
Yeah. Frank, can I just jump in on that one?
Yeah, go. Sure.
Yeah, so I guess, Bill, it does depend on the governing docs, but it's usually between 20 and 30% of the members. If they sign a petition, they can compel the board to hold a special membership meeting for fill in the blank. Oftentimes that's like amending the governing documents. So it's usually 20 or 30%, but like Fran said, you got to check your governing docs though.
Yep. Yeah. So that's. I am not a big. I'm sure you've heard this from me before. I'm not a big fan of things like petitions and surveys. It's usually a bad sign in terms of the community itself. But I am a big fan of the board governing as the elected body. I don't like to see when the membership starts directing the board. So that really turns into a mess. So there's a couple questions on the fee schedule Ray put up there. I don't know if these are caps, Ray, you may know, but if so, I got really ripped off by this car dealer from wherever they were, because it's like $250 for a notary, $15 for a notary, and I paid a lot of money. So I need to sue somebody who's in. I'm going to find that lady's business card and sue her, but no, I'm not. But I like the car, or at least my wife likes the car. But there is a fee schedule. Carl mentioned that many banks will notarize for free. Like I said, the problem with many banks is the branches are closing. A lot of banks are going online, which, by the way, this is just general information. I'm not a financial advisor. A lot of the banks today are really offering much, much higher rates. So if you have money in a savings account, you might want to take a look at that, because the rates have really bumped as the Fed has increased rates. Reacted to Chapter 11. Oh, okay, there's the fees. Heather mentioned that. The state manual says you may collect. There you go. You may collect. So that's correct. Ray says, yeah, you're not compelled to collect. Fidelity on Route 1 notarized my new will with no charge, and I have accounts with Fidelity. Madeline, that's great. I mean, if the banks are still out there notarizing things for free, that's fantastic. Chip Hoover said 2.5% on money market and 4.5 on a 13-month CD. Yeah, Chip, I mean, that stuff's out there, 4.5%. I've even seen 4.25% on, I think, savings accounts, unbelievably so. That's like 1978 stuff, right? Like pretty soon we're gonna, I think I was paying 9% on my guaranteed student loan. That's insane. But for those of you who have reserves, reserve funds where you have tiered CDs coming up, I know this is off topic, you should be talking to your financial advisors as to what to do with them, whether you should be putting them into long-term instruments, short-term instruments, et cetera. Again, I'm not a finance guy, but especially if you have tiered CDs coming up to maturity, make sure you're looking at that and make sure that your financial advisor is doing her job or his job and presenting options to you in terms of where the market's going and where you should be making money. Yeah, Jim says 5 months on 3-month treasury bills and almost as much on 3-month CDs, right? So the money's out there. And, if this was 3 years ago, we'd all be talking about, oh, we have all our money sitting in there and making no money, right? Right. It was like basically 0% interest for a long, long time. So to the extent you're able to, within the framework of the Prudent Investor Act and your governing documents, limitations, talk to the association's financial advisors. The one thing you don't want to do is what people did during the .com bubble craziness is take your association's reserve and put them into risky investments, right? Because a lot of people got burned in the .com bubble burst. So be careful. Certainly look and certainly poke around, but don't go crazy. Just don't put more than 250. Jim says don't put more than 250 in any one bank, particularly regional banks, right? So that's been a funky thing, right, for the past month, 2 months, 6 months, et cetera. Is with certain exceptions, 250K is the cap for FDIC insurance reimbursement. So you want to make sure you're in different financial institutions. And as you know, there have been a couple regional banks that have been either in severe trouble or have collapsed altogether. And the government has wind up bailing them out, but they're not obligated to bail out over top of the 250 FDIC limit. Again, there are some exceptions to that, but so be careful of those things because we still don't know where this economy is going. I know there's some of you are finance people on the call. I don't know how this economy is working right now. It really baffles me, but we'll see. And by the way, for those who are on the finance committees of your associations, we are still not seeing a significant uptick in accounts receivable or bad debt expense. Not seeing it. So I don't know if any of you out there in the field are seeing it, but in our collections practice group, we are not seeing it. Maybe a tiny bit, but nothing crazy. I can't imagine that these rate increases will not push some of these association members into delinquency. But maybe right now they're still running on credit cards. I don't know. The inflation has been so crazy in terms of everything across the market. I just can't imagine that people are able to pay these prices. Clarify, I heard you correctly, please. You had said earlier, don't sign a contract and then bring it to the open meeting, sign a contract at the meeting, but that would slow down getting things done. Yes. So Lori is so right. It does slow down getting things done. The contract has to be approved at an open meeting and then it's signed afterwards. You don't sign the contract and then get it approved in an open meeting. That's where people get jammed up. So yeah, you're right, Lori, and it can slow things down. If you do need to have a contract signed, and there are emergency caveats to that, but you can't have a pretext for an emergency. But there are caveats to that where you can have a special board meeting solely for the purpose of considering and signing that contract. That's easy enough. Jim said, yes, went from 25K pre-COVID to about 80K now. Well, that's nice, Jim. It's nice to see that. Carl says a lot of communities have been moving money to money market accounts. While the funds may be recovered, the time to recover can be years, and there have been M&M that have broke the bank. So, yeah, I mean, there are a lot of governing documents that say all funds must be FDIC insured. There are governing documents that say they may only be in a savings account. You have to really look at your governing documents on that. For those of you, I don't think we've done a Prudent Investor Act discussion on First Friday with Fran. Maybe we should. So New Jersey has a Prudent Investor Act, And where the Prudent Investor Act came, and there's some debate over whether or not this applies to community associations. The Prudent Investor Act was initially aimed at trust funds, where trust organizations would be so-called, quote, managing funds for these wealthy estates or wealthy trusts. And all they would do would be park a big chunk of money in totally bulletproof investment vehicles, and they would be collecting their management fees like crazy and really not doing anything. So part of the Prudent Investor Act was that if you're going to charge a management fee or a financial charge for managing people's funds, you have to take reasonable steps not only to protect the money, to invest it reasonably, such that you earn your keep in doing that job. So there are some issues with the Prudent Investor Act, because I've often taken the position that the Prudent Investor Act perhaps does not apply to associations, because one of the main things with associations is protect the principal, not make money. Know that the money will be there when the roof is at the end of its useful life, or the pavings at the end of its useful life, etc. Let's see. Jim says, I meant for my receivables up from 250K. All right, so Jim, I'm sorry, that's wrong. So your receivables went from 25K to 80K. That may be a good thing or a bad thing. I don't know what your budget is, right? So if you have a small budget there, so a jump from 25K to 80K is big, right? So that's a big jump, especially if you have a small budget. Yeah, Jim's shaking his head. He's like, yes, I do. Well, we don't like that. Well, we'd be happy to do the collection work if we're not doing it for you already. We are very, we'll say, nice and friendly and persistent. We'll be very, very nice to you, but you got to pay the darn bills. We are very insistent in paying the bills. We do a whole bunch of collection work for associations, but you got to pay the bills. So he's got a $1.5 million budget. Okay, so that's, that's not a disaster there, Jim, but the uptick from 25K to 80K is not a happy time. But as you know, this could be one or two people. You get one or two, there he's got three. So you can have 1, 2, or 3 knuckleheads who are jacking your receivables, and those people really shouldn't be living in your community, generally speaking. They're going to have to go find another living arrangement, because certainly they're not willing to pay in your community. That being said, it seems like that's a wrap. Jim's comments were the last ones. Unless anyone has anyone else, we're going to take off. I see the sun breaking through. And I'm glad everyone came. It's great to see everyone. And we will see you in June when real summer will be on the way. And we'll be looking for the beach and heading back down there. So great to see everyone. Thank you so much for coming. And we'll hope to see you soon. Take care. Bye-bye.